Welcome back. We're going to do our usual. I don't think there's any administrivia. Reminder that next Wednesday we will not have class as usual. You'll have your Tuesday class. That's the only administrivia that I'm aware of. Moving on, then I'll give a brief recap of where we are, and then I'll expect your questions about anything we do in the class. We'll then move straight into our closing up of direct and consequential damages, our discussion of lost volume sellers and mitigation, and then we'll move into reliance and restitution as a matter of contract law. So that's where we are. Everybody knows the overall structure of the class, right? We have contract formation, formalization, interpretation, defenses, and now remedies. And within remedies, there's kind of an ABC structure where the A has sort of a 1-2 underneath it. That is, the ABC structure is expectation damages, right, reliance damages, and restitution damages. Those are our three big frameworks for damages for breach of contract. I know the whole class we've also been talking about reliance and restitution as part of something different, but I did warn you at the time that reliance and restitution weren't just these independent causes of action that we bring when somebody breaks a promise that's foreseeable that somebody else is going to rely on. It's not just for that. It's also for doing things like recovering damages when expectation damages in a breach of contract case would be too speculative, and so on and so forth. So we've got our big three, expectation, reliance, and restitution, as our models of damages. Expectation is the huge one in the room, and so we talked about the general standard of expectation damages, which is typified from my mind in 1305 of the Uniform Commercial Code. The idea that the purpose of the expectation measure is to put the party in the position that she would have been in had the other party not breached. Notice that's already in tension with our reliance standard, which puts you in the position that the party would have been in had the promise never been made, right? That's not a contradiction. It's just simply when you use these different tools at different times. And so we've got our overarching matter of expectation, which is 1305, what I'll call 1305 world, or what we've started calling in this class, the uncracked egg world. And then all of our problems tends to flow from the uncracked egg problem. First of all, why we're deeply unhappy if the court says uncrack the egg, like actually does it as a matter of court order, gives an injunction to specifically perform the contract, that specific performance. We don't talk about that a whole lot under our expectation measures of damages, but it is the international standard under the Convention on the International Sale of Goods, so like keep your eye on that ball, and we do get it in cases like we're going to see today in all metals. There's an expanded use of specific performance under the Uniform Commercial Code that actually does get out there. So that's our step one of uncracking the egg, is this sort of court order where the court says from on high, uncrack the egg. And you're like, well, but I can't, Your Honor, because that egg is cracked. Like that egg was cracked 2 years ago. That's why we're in litigation now. That egg has been cracked for 2 years. We're not uncracking anything here. The court still may give that order. By the way, you should expect to be profoundly disappointed about the results of a specific performance order, because you can't, right? Imagine a fight over cars like we had in Simeon most recently. Those cars have been resold. Like they were resold years ago. You're not going to get a court order saying, sell me those cars right now. That's why we end up having to use things like 2713 to give a remedy to the party there, because specific performance is very rarely as sexy as people think it is, right? Like we are years down that road, and it's not gonna give you what you want. But it's still a valuable remedy. I guess as we saw in Simeon, the thing to take out of that case that's really interesting is, and that's not a specific performance case, but in a specific performance case, you're unlikely to get a court order saying, sell me the car, because we're way past that point. What you are likely to do is say, when you sold the car, it was my car, and you should disgorge the profits you made in selling it into the new market, which has some really weird implications for our efficient breach model, right? Like that at least is what they're trying to do with that specific performance. They're trying to capture that sense that maybe opportunistic breach of contract shouldn't benefit people. Shouldn't it though? But maybe it shouldn't benefit people who we see to be acting badly, and the specific performance remedy is a way of capturing that, because your damages are not going to be the damages the party would have had if the contract had been performed. I'll give you proof of that. Let's imagine you sold into a falling market, right? So if the contract hadn't been performed, you would have resold those cars for a whole lot less, and maybe your expectation measure of damages would have been pretty reduced. But by doing specific performance, you're able to capture the breachers' rise in the market that they saw coming, right? They saw that rise in the market coming, they breached the contract, they resold into a higher market. By using specific performance, you actually usually don't get a court order full stop to convey the cars. What you tend to get is a court order saying that the rise in value captured by the breaching party is in some degree owed to the non-breaching party. That's how specific performance works out. But we're still under A1. A1 is specific performance. A2 and 3 then are going to be our far more common remedies. A2 is going to be your alternative market performance. Your alternative market performance is what the court's desperate for you to do, because the court lacks institutional competence and the ability to read minds. It has no idea how to solve the objectivity and subjectivity problem, and it absolutely does not want to, because if it has to, its golfing weekend is gone. And so what it's going to do is absolutely anchor, and that's what we saw in KGM. It's absolutely going to anchor to that alternative measure of performance. And this was kind of related to Mike's question earlier. We see that happen most often in thick markets. The idea being, your contract was breached? Okay, I hear they have catalogs with this stuff. Why don't you buy it from somebody else and we'll work out the difference? But at least if you buy it from somebody else, you don't suffer these downstream effects, because you don't get a widget, so you can't build your gadget, and then you can't sell your gadget to your customers, and that causes that supply chain collapse that we talked about of consequential damages. So courts love this alternative performance metric. It's just we've then explored a whole series of cases having established that where the alternative performance metric falls apart for some reason or another. We saw it because it was a thin market, right, in American Mechanical, because we just didn't really know what the hell that land was worth, and so the court was all over the place in trying to establish a price in that thin market. And then we see other cases where there's a relatively thick market and the court's just like saying, look, you needed to cover by buying it from somebody else. But at least in the couple of the cases we saw where thin markets tend to push us to a different remedy, and thin markets in fact do. They push us to this, Simeon style remedy, where you're doing a hypothetical market cover. Why? Because antique cars like that are not to be purchased for love or money just out there on the market. And so you're going to need that hypothetical market cover, where market cover is either unreasonable or impossible. Now, Simeon shows us the set of circumstances where an alternative market cover is probably impossible, because the goods are getting pretty close to specific performance territory there, right? Like, they're pretty unique. And so that makes it a remember, specific performance is reserved for the ultimately thin market. There is only ever one of it, right? So, but as we're moving away, from the ultimate thin market, we use specific performance. For a medium thin market, we might end up using the 2713, or under the restatement of law, this hypothetical market cover. There's just two problems with it. One is we use it when you probably can't arrange an alternative market transaction. Resale if you're the seller, that's your alternative market. Or cover if you're the buyer, that's your alternative market. You can't do it because there's an ultimate thin market. There's one other time when you pretty commonly don't get that relief, and that's when you did arrange an alternative transaction. You just screwed it up because you got greedy, and you, for example, if I promise to sell you my truck, you agree to buy my truck, right? Then I breach and you go buy a Cybertruck out there. Theoretically, at least it's worth more than my F-150 that doesn't move. Then you have done too much in your cover transaction. And so what do? We're going to limit you to what you would have recovered if you had acted reasonably. So on the bar exam, when you're looking for whether you use 2712 alternative deal or 2713 hypothetical alternative deal, and the same parallels are in the restatement, the one thing you want to look for is, one, is cover possible? Like, could you have gone out and gotten it, or is it a really thin market? And then two, if they did do cover, they're going to presumptively get cover damages. CKGM, where the court's like, windfall, schmindfall. I don't care. I'm going to give somebody a huge windfall just to follow the statute. But if you unreasonably cover, the way that they will signal it on the bar exam is in a private sale, you do not tell the person that you've seized the property from that you are about to resell it at auction. That's a big one. The notification requirement is strong enough that they regularly put it on the bar exam. And I'll also say you have to advertise the resale and you have to paint it, right? That's what I teach in my upper level classes. If you're going to do that alternative transaction, especially a seller reselling, right, under 2706, 2708, those are our standards there. If you're going to be reselling it, you have to advertise that you're about to sell it. You have to tell the other party that you're going to sell it, and you have to paint it. You have to do reasonable, inexpensive repairs that get the thing ready to go. Now, the reason that I raise that is because it really gives Laura's sort of intuition about this some real teeth, right? Let's say you would have let's say you didn't paint it, or you didn't advertise, or it wasn't a competitive auction. Well, then opposing counsel is going to come back and say, well, we're going to limit your damages to what they would have been, to the price you would have gotten on resale if you'd have reasonably advertised it, to the price that you would have reasonably gotten on resale if you would have told the other party who's got a vested interest in rounding up investors and getting them in that auction room, because of course the higher people bid for it since it's been repossessed from them, the higher, or rather they breached the contracts and now they're the guarantor of your shitty sales price. They want the most people in the room possible bidding on this, and so you would have had you told everybody you were supposed to, you would have gotten a better price. If you'd have painted it, you would have gotten a better price. It's not enough alone to say, on resale, the seller got a crappy price. That's because all resellers are usually reselling fast in a fire sale market, and we talked about that. And you can either sell things fast or you can get good prices for them, but you sure as hell can't do both. And so courts perfectly well understand that just like a cover charge might be a little more than the direct market because you were moving fast, and that's fine. In the same way, right, here courts are going to say a resale price that's below what you would get if you were selling it on a market and took your time. That's fine too. Getting a crappy price alone is not enough. But if you didn't advertise it, tell the other side, or paint it, those kinds of things that show commercial reasonableness in the alternative transaction, then the court will ding your damages to the extent that you would have gotten a better price if you had followed these rules. Now, these three rules of paint it, advertise it, tell the other side, those are drawn from the Uniform Commercial Code, but you can see that the rule generalizes really fast. Follow industry custom and practice in arranging the alternative transaction and keep your receipts, because you're going to need to show them to the court. But if you do that and you acted the way your industry acts in a moment like this, you're going to be fine, even if your resale price is lower than the Kelley Blue Book, or if your cover charge is higher than the Kelley Blue Book because you had to do it fast. All right, that's a lot. I hope I've raised some questions in your mind. Let's go ahead and review that and anything else that we've done in the class so that we can then get on to mitigation. Chris?
Can you just briefly give the rule of law in Crafter UOP?
Yep. The rule of law in Crafter UOP is that a lost volume seller can meet additional demand that is defined by the ability to meet additional demand. However, when the second transaction was but for caused by the first transaction, by the first breach. So when the second transaction was but for caused by the original breach.
Can you put this into like an example?
Sure. The idea here is we have only a few refineries, very few refineries, right? So let's say we've only got 5 refineries in the world. We're about to see this, by the way, like we're about to see exactly this analysis in a later case, so we can practice it again after we do it. Let's say there's only 5 refineries. Now you've got a patent, so you could patent 100,000 refineries if there were 1,000 refineries, but there aren't. There's only 5, and let's say further that you've licensed to all 5 of them. Well, when one of them then kind of goes bankrupt and gets sold to somebody else in bankruptcy, that you then have a second transaction with them for that 5th refinery. The original breach is the but-for cause of the second license. If they hadn't breached, you wouldn't have had a refinery to license to. Make sense? Yeah. That's the Craftsor hypothesis. Generally speaking, in the rules out there on lost volume sellers, and we're not done with lost volume, we get one more chance to practice when we do MTI, when we do MCI. The lost volume seller rule, what we need to point out is it's generally easy, but there's one Craftsor trick, and this is the Craftsor trick. It's generally easy. Can the non-breaching seller meet additional demand? And then under 2708, it's arguable, and we do not have time to go through that statute. There is one statute that's worse than 2207, let me tell you, and that's 27082. So do not read it. You're not allowed. I'll just tell you what it says. And it says this, but holy crap, that thing's a nightmare if you actually try to read it. But anyway, that's the overall framework with 2708 when you are conducting a resale and you're trying to get that alternative. Follow up on that or anything else?
I think I understand.
Cool. It's just but-for causation as a way of getting around the weird problem where, as an intellectual property licensor, you could meet additional demand. But there's something not quite right here. That's what Craftsor stands for. Nate.
On the topic of lost volume sellers, there was the hypothetical in the book where it talked about like a house construction company where the cost increases as you make more.
Yep.
And that may affect the calculation
Yep.
for damages. Is that something that we should kind of understand?
You should. And the way that you should understand it is after you do your formal lost volume seller analysis, you will remark to me that you are aware that all sellers are in fact, in the world, partially lost volume, especially as they approach production cliffs, like needing to activate additional production lines or paying overtime or paying the night shift, stuff like that. At that point, you're going to begin to see those strong differences. Everybody is, and this, by the way, MCI is going to drive this point home. Everybody is kind of lost volume and kind of not. I don't want you to get trapped by this sort of black and white dichotomy, saying like that you either are or you're not. There's a lot of use in saying, oh, everybody's kind of the one and kind of the other. Like, I'm not a lost volume seller for trucks, but I probably am a lost volume seller for at least a few cars. Like I got a couple lying around the place, right? That kind of thing. Everybody's kind of this, and that can help you push a case into one side or another as you litigate. Liam.
Staying on lost volume, if, for example, you're a lost volume seller for like a pretty physical good, like a car,
Yep.
are you going to recover the full price of the contract, or are you only going to recover your profit?
You will only recover your profit unless, here's the answer, it's upper level. You'll only recover your profit unless they have accepted the car or you've made it available to them so that they can come take it, at which point you get a very specific kind of specific performance, which is called an action for the price. You simply, if they've got the car, you sue them for the car cost. You sue them for the car price, the full contract. If they don't have the car, you get your lost profits.
Yeah.
You see that?
And the car back.
Well, you keep the car. Yeah. You either get your lost profits and keep the car, or they've got the car and you can sue them for the price. Make sense? Cool. And I always found that one weird. Like if anybody really wants to poke their brain around that, that's a very strange one. We say specific performance is so rare. It's freaking not. If they've got the deal, the court order pay them the money of the contract, which is the one side's performance, is like every day. It's wild. It's wild. Further questions on anything we've done in the whole class, Riley?
I had a question that
Yep.
I think you just answered, but I don't have my participation on it.
Sweet.
So if a seller reneges on a deal and the buyer goes out and buys a really expensive F-150,
Yep.
they're not allowed to do that and then claim the difference. Likewise, if a buyer reneges, the seller can't go and sell your truck for 1 red cent because it's not commercially reasonable.
Because it's not commercially reasonable, and so what's the court going to do? Yeah, what would have been commercially reasonable if you had, for example, not just sold it to your cousin Earl for a cent.
So you should have sold it for $800, so now you can only recover the $200 difference.
You got it. What your damages would have been if you had acted reasonably. Yep, exactly right. Exactly right. Valeria. Yeah, right. So first of all, let me be very clear. I'm going to give a clear answer. What I need you to understand is that a lot of the value in being an attorney, especially in UCC cases, lies in blurring my answer. All right. Now that's largely because the UCC does not include consequential damages for sellers. It just simply doesn't have those words made available to sellers, which means you have to pack some of these intuitions about consequences of the breach into incidental damages if you want to recover them under the UCC. It does permit consequential damages for buyers where the seller breaches, and we discussed why, because the buyers under the UCC are part of an industrial supply chain, and they are generally selling their own things forward, and that downstream breach of contract is a clear consequence. It's not the original breach of contract, it is a clear consequence of that breach of contract. And so 2715 really sets out consequential damages for non-breaching buyers, whereas it doesn't do that for non-breaching sellers. I have to say we tried to revise Article 2 to fix this problem because there are some circumstances actually where you might be able to say a seller suffered consequential damages as the result of a buyer's breach. But because we can't have nice things, just because the various entities that create the Uniform Commercial Code no longer are really talking to each other, except like yelling through closed doors and things like that. Because of that breakup, we're not able to really effectively revise Article 2 of the Uniform Commercial Code, and so we haven't been able to change that. So having shown you why blurring the line is actually mostly your job, let me draw the line and make it clear and distinct as possible. Here's the distinction. The incidental damages are damages incidental to arranging an alternative transaction. The consequential damages are damages that either flow naturally from the breach because of the type of damages they are, or are damages of which the damaged party has made the damaging party aware as part of the contracting process, such that they meet the Hadley versus Baxendale foreseeability standard. Now, I need to show you why in most cases these are alternative, which is, look, if you have the costs of arranging an alternative transaction, you probably arranged an alternative transaction, which means that you blocked any consequences of the breach that would have happened, because you did get the widgets, and so you can meet your forward contracts. You can meet your next set of contracts because you got the widgets that you needed for your gadgets from somewhere else, right? So generally speaking, the confusion is caused because it's either one or the other. You either arranged an alternative transaction, which means you cut off a lot but not all of the consequences, or you didn't arrange an alternative transaction, in which case you don't have incidental damages, but because it wasn't useful, like arranging an alternative transaction wasn't going to help you, see our lost volume seller rule, right? That wasn't going to help you. So in that case, you don't have those incidental damages relating to the breach. And even then, it would be weird if you did. I want to describe the problem before we get deeper into it. It would be a little weird if you did. Like imagine a lost volume seller rule where we all understand I'm able to sell 30 cars today if I want to, right? I can just sell all the cars I want to. I'm clearly lost volume. You can imagine it would be a little bit strange to say, well, Fred breached, James comes in, that's the alternative transaction, so therefore the costs of me negotiating with James ought to be damages that I go after Fred for? No. This is just a separate transaction, separate profit, separate deal. It wasn't really a replacement transaction because the second transaction can't really replace the first. So there were reasons why they did it this way. I want you to see immediately, of course, though, that lost profits could be considered, are considered consequential damages in many areas, but you can receive lost profits under 27082 as a seller. So that's weird. Even though it doesn't expressly allow consequential damages, we get lost profits for sellers all the time. And incidental damages, like you can push things in and out. If you're a seller and you suffered consequential damages, you might be able to convince a court that these are in fact incidental, they're part of that you had to arrange an alternative transaction because of the breach, right? That it's a consequence, and it's an entirely foreseeable, Hadley versus Baxendale, consequence of the breach. And so courts are kind of willing to open the door to incidental damages for non-breaching sellers under the UCC to kind of compensate for the screw up in the code. But what I need you to see is why generally speaking, very generally, you have an alternative transaction, that means that you've mitigated. You did what you were supposed to do, and so we're not as worried. We give you your incidental damages and then your replacement transaction difference, the difference in the resale price or the difference in the cover that you got in your alternative transaction. We're not going to generally give you, the problem is created by this. Even if you do arrange an alternative transaction, you're not required to seek cover or resale damages. You could, you have the plaintiff's choice. You can just seek hypothetical market damages. And so that creates some confusion where the party did arrange an alternative transaction, but then chooses to go under 2713 or the like, or its parallel, in which we're saying this is a hypothetical alternative transaction. And if you're suing for a hypothetical alternative transaction, you probably shouldn't get the incidental damages related to arranging the alternative transaction that you're not pleading as part of your lawsuit, right? That's the sort of core tension. There are some edge cases that really cause some problems there. We tried to change the law to capture those edge cases. It hasn't worked yet. So now what happens is courts tend to pack for sellers the consequential damages. They tend to pack them into the direct damages under 27082, or they pack them into incidental damages, which sellers receive. Any further questions? Loving these the most. Okay, got Aiden?
Do both parties need to be aware that an item is unique for you to recover, like the thin market price?
Oh, sorry, I had Aiden's hand up, and then I'll come right in front of you here. Go for it.
So in the context of consequential damages, could you help kind of situate the idea of the ability of community in the
Yeah.
context?
Absolutely, especially for the big move, because of the wording mistake of 2708 and the like, 2706 and 2708, which are your resale and hypothetical market alternative damages. Because of some mistakes there, the recharacterization of consequential damages as direct damages is the particularly strong one. Was there a follow-up on that? Okay, great. That's a great question. And then, sorry, you and then Liam, go for it.
So I guess you were kind of explaining this, but can you explain the black letter law of the lettuce case? Because I feel like the
Yep.
consequential damages, so they were available to the buyer, but the buyer had already offset.
Well, this is part of Valeria's question. There aren't consequential damages available in KGM because they covered. They got the lettuce.
Yeah. But they still were covered.
Well, there's a lot of conversation there about a particular problem that I was hoping to avoid, but thank you, you've noticed it. Look, this gets harder, folks, at the upper level. I don't want to take a lot of time on it. I can show you what's going on there. We've talked about supply chain collapse and those huge amounts of damages that can go to a party if they turn out to not be able to cover. If you saw in KGM, there was this discussion of like the Allied Canners case and other cases like that. And what they started to do was unpack the damages remedies of KGM and of our contract resale and contract market damages. And the problem is that the way that those statutes are written, they do include like all of these different categories. And what courts began to do was notice something. Let's say I'm in the stream of commerce. I'm the middle person, right? I'm the one in between. Let's say I buy stuff at $1 and I sell stuff at $2, right? Now, if my upstream contract collapses, what are my lost profits? Let's say I do 500 units a year. I buy them at $1, sell them at $2. What are my lost profits? The dollar that I'd be selling it for each time. If I have 500 transactions, roughly speaking, my lost profits for that year would be $500, right? That making sense so far? Can you see that, like, let's say that the value of this thing that I'm selling, because of market changes unrelated to any of this, but these are all market change cases, OPEC, the Allied Canners case, there was a drought that wiped out the raisin industry. So these are always places where there's this market shock, the prices go through the roof. Here's what I need you to see to answer your question. Let's say that the widgets that we're buying at $1 and selling at $2, suddenly because of other market shifts, the price of those explodes to $50. Now, what does that do to the person in the middle? Because under these statutes, if you read them, they're going to get their lost profits, and they're also going to get this huge amount of money from the downstream, because this is going to collapse and those prices have gone through the roof, and so those numbers each time are just going to be astronomical, because it's going to be a market price minus the contract price, and we just stipulated that the market price went through the roof. So that gap is going to just be getting huge and huge and huge, and that big bubble, like think of these old school 1920s or whatever cartoons, right, where somebody's blowing into a hose, right, or drinking from a hose, and there's this big bubble that kind of moves along the hose. That's what happens to this massive glob of damages that just rolls and rolls and rolls as it goes downhill. And so when courts see that, they do have a different response than they did in KGM. And that's what KGM largely said, was like, nah, we're not doing this. But what they do say is that, like, look, you can either get your contract market damages, that big bubble, or you can either get that contract market damages, or you can get that downstream consequential damages, but not both. Because what they noticed was in KGM, there was a huge freaking windfall. And so courts started using 1305 in 2713 cases. KGM is a 2712 case. We actually do have an alternative transaction. But they start using it in 2713 cases, like Allied Canners, to say, you're getting a double recovery here. We're going to limit that windfall to the greater of either your market contract damages or your consequential damages for lost profits, but not both. Allied Canners in particular took a really strong stance that really caught people's attention. It's not really the law, but people need to have it in the back of their mind, because what Allied Canners said was they noticed something more important. Look, let's say I have a contract for raisins. Every raisin I buy for $1, I can sell for $2, and I can buy and sell a lot of raisins. If the price goes up to $50, why should I be the one to capture that rise in the market price? Who should capture the rise in the market price for those raisins? Yeah, and by the way, if they're locked into a sale price there, then who should get it? Whoever right? There is a person at the end of the line who has contracted for the good and had the foresight to contract for the good, the price of which has gone through the roof, right? There is a person there who made the right bet in the market. Why the hell wouldn't we reward them rather than one of the upstream or intermediary buyers? There's a lot of discussion about that case in particular, and whether or not it depends purely on another fact in Allied Canners, which is essentially that the Japanese companies that they downstream breached to, their downstream buyers, had basically for cultural reasons decided, we're not going to sue you. So they knew that there wasn't going to be this huge snowball, and they're like, you know what? We're just going to give you your lost profits. We're not going to, you were locked in. You were locked in. You knew how much money you were going to make that year. It's unfair to give you so much more because the market went up when you had already committed to selling what you bought at a given price. You had made a bet against the universe that was too low too, right? We're not going to give you more. So the rule that I want to give you, though, in KGM is courts are going to give you that huge windfall. They're not going to give you the huge windfall and the snowball. Among other things, because the windfall was related to an actual transaction that covered, so there was no snowball. There was no snowball. They cut off that supply chain collapse. They got the lettuce from somewhere else. They stopped it. So that's one reason. But then when we get into 2713, where they didn't stop the snowball, because we're doing a hypothetical market transaction, we don't have the lettuce. All downstream transactions start to collapse, right? There, sometimes courts will look at the facts of the case and go, we're going to give you either that huge market contract difference, or we're going to give you that snowball of consequential damages, of lost profit consequential damages, but we sure as hell are not going to give you both, because you're already recovering way over your actual expectation. Because remember that year, you just thought you were doing 500 raisins at $1 in, and 500 raisins at $2 out. You thought your bank account was going to be plus 500. You didn't think it was going to be plus 50,000 or whatever. And so the courts in 2713 cases will start to limit that. It's upper level stuff, but I think it's useful because, like, you raised it, and that's what the Allied Canner stuff in the case is all about. All right, I got a couple more. Talia.
Sorry, I just have a quick clarification.
Yep.
In these like commerce street cases, every intermediary gets to recover for the market price, not just the one who actually sells for the market price?
Yeah.
Oh, okay.
Yeah. No, it's turtles all the way down in a 2713 case where you don't get an alternative, right? Think your supply chain is collapsing, right? If somebody covers, your supply chain is no longer collapsing because stuff's been routed into your system from the outside and then all the future deals work, right? But as long as that supply chain starts collapsing because cover's not possible, and that's gonna be circumstances under severe market conditions where the good that you've contracted for is simply not available, like you just can't do an alternative transaction because it's not to be bought. Those are the ones where we start seeing these full collapses, and that's what raises this problem, because in these full collapses, big surprise, the price always spikes. And then you've got you've got two problems, this huge chunk of difference between the contract price and the market price. That's part one. And then you've got this other huge deal, which is the snowball effect from going downstream. And courts then tend roughly to use under a case called text par. They tend roughly to say, we're gonna give you either one or the other. We're not gonna give you both. Okay, Nate, yep.
Just like a clarification. So like if it ended up being turtles all the way down, the court would have to look into like Fresh Chef, McDonald's, all those different
Yep.
folks. Okay, got it. And then secondly, if cutting off the supply chain creates this big snowball,
Yep.
whereas cover saves it and
Yep.
cost maybe less.
Yep.
I guess you would be incentivized to not get cover, but you can't do that because if you can get cover, you have to reasonably get cover.
Yeah, because if you can't get cover, you must mitigate, which is a good transition to our discussion of mitigation, right? If you can't, that's 2715. If you can cover and you don't, you lose all consequential damages. Hey, here's the Laura rule again. If you had acted reasonably in mitigating, then we would have blocked those consequential damages so you don't get them, which is what you look for on my exam and on the bar exam. If they don't cover, look to see if they could have.
But they also only needed to have made a reasonable attempt to cover. How do you know?
You go custom industry and practice and you keep your receipts. Great question. You really show like how hard you tried. All right, let's turn, I think this is a great segue to turning to mitigation, because we're gonna just finish up our discussion here around the obligation to mitigate and some rules that you basically know already. And so, Jake, I'm gonna ask you to set up In Re WorldCom, and then I'll ask Elle to respond to it, and we'll take it from there.
Okay, so in WorldCom, Michael Jordan had an agreement with WorldCom, subsequently known as MCI, for a 10-year license to use his name, image, and likeness, and other attributes and personal services, basically as like an endorsement campaign. He would have to make himself available 4 days of the year, each day not to exceed 4 hours. They would produce commercials, advertisements, all that kind of stuff. WorldCom goes bankrupt, and Jordan sues for the lost profits for the years that he was contracted for but had not been able to, because of WorldCom's effective breach by their bankruptcy.
Right, okay, so WorldCom's got this relationship with Michael Jordan. They breach because of their bankruptcy. First of all, I want to watch. Who's the pressure on in this case, Jake? That's interesting, because like at a meta level, who's the bad guy here? Before I ask you whose client you've got.
Theoretically, it would be the breaching party.
Yeah, theoretically, it would be the breaching party, right? It's going to be WorldCom. They breached, right? Whose eyes are we on the whole damn case? Jordan, right? This is just like the cleanest example of what I've been talking about. When you get to remedies, the bad guy shifts. It's not a question of whether the contract was breached. We're past that point in the class. The question is, what are the remedies? And there's at least a really strong argument that you can get your people down for. Now, do you want to take the position that Michael Jordan does need to mitigate these damages, or that Michael Jordan does not need to mitigate these damages? That he does need to mitigate these damages. Okay, so I'm going to give Elle a chance to give your opposing opening statement. What's the best evidence we've got that like he absolutely, yeah, go for it.
He's a lost volume seller, like,
He's a clearly,
he only has to do, like, the contract is worked for 16 hours a year, so technically it's not unlimited volume, but pretty practically it is unlimited volume. You could get any other contract.
okay. So we're going to start there. Clearly lost volume. You see that, right? He's got more time in the year to use. It's only a couple of days. And he could have done more deals with more people. He could have done more endorsements. So clearly lost volume. Jake, your response?
He is not a lost volume seller.
Not a lost volume seller because?
While he might have theoretical unlimited capacity or ability to sort of make himself available for more endorsement deals, he was not actively seeking those out. And so he can't really just sit on that and then use that as a defense. He has to actually make an effort to sell.
And what evidence do you have in the case that that's true?
So he cited that he was worried about for one, he wasn't his spokesperson, I believe, or his financial business advisor said that Jordan's desire was not to expand his spokesperson or pitchman efforts with new relationships because he was worried about diluting his image and the value that he would receive from those sort of contracts. And he was also concerned about his image as an MBA owner, and he didn't want to diminish his image or reputation on those grounds. So he was not going out and looking for more endorsement deals.
Okay, so he's not going out and looking for more endorsement deals. What's your response to that? I know you're in the harder place here, so I'm cheering for you.
Maybe that at the time that the contract was made,
Yeah. At the time the contract was made?
he could have found more endorsement deals had he known that this contract would have been breached.
Right. That is, he may well have expanded the number of endorsements he made knowing that this was going to happen. And what's your response to that, Jake?
That he should have known they would have had to.
Well, so L's response is, wait a minute, no, he can still take on, this is the additional supply stuff, right? Like L's hammering home her strongest point, which is the guy's got additional supply of standing in front of a camera with his thumbs up for like, a video short. Like there is more supply where that came from, right?
He wasn't making an effort to sort of sell his image and sell himself as an endorsement, and that's, you sort of have to make that.
Well, wait a minute. Is he required to do that? Is he required to seek an alternative endorsement? Would he be required to seek an alternative endorsement if he had breached to mitigate his own damages? No, tell me more. Tell me why not. You're doing great.
Well, if he, yeah, like,
And if you want me to open up to co-counsel, it's fine. But you're on the right track. Like if he had breached, right? What's the theory under which going and getting another gig would make sense? Where we would say, yeah, we're going to make you do that. We're going to make you go get another gig. When would that matter?
I guess when he couldn't get, like, if him, I'm trying to think of how to word this, but like, if he could only do one contract at a time.
Yeah, right? If he could only do one contract at a time, then this breach, right, would have freed him up to do that. But is that the case here? No, not at all. And in fact, so all we're doing is flipping the standard around and saying, wait, if we use the cases like the actress cases, right, where we're saying we're not going to make you go do alternative work when it's a crappy, like you're supposed to go to Australia and do a cowboy movie, et cetera. We're not going to make you do that, right? And so we're not going to make you do this as an alternative contract too. And two, that's a mitigation action, and it goes back to your original point. If his point is like you didn't mitigate, then your response is, well, I'm not required to. As a lost volume seller, I in fact can't mitigate. It doesn't matter whether I was seeking additional endorsements, Your Honor. It doesn't matter whether I was seeking additional endorsements because those would not have mitigated the loss from this particular breach. Jake, what's your response to that?
He's still not a lost volume seller at all because he made it clear that he was not looking for other endorsements.
Right, so what does that cap do then to the MCI breach, or to the WorldCom breach? When he has that cap, what was how many endorsements was his cap at? I think they mentioned it.
It was at, I think 4 days, 4 hours.
It was 4 days, but let's just imagine. Go ahead, Lucas. The 12. Like I think that's right. We'll say, let's say he says, look, you know what? 12 endorsements is about the max that my reputation. Like I don't want to get overexposed out there. This is clearly before TikTok. I don't want to get overexposed out there. I don't want my reputation diluted. I'm going to cap it at 12. What does the cap do? Why did your law firm work so hard to get this testimony? Because this is a practice tip, right? I want you to see what the manager didn't just say this stuff about not wanting to dilute the reputation. Like he didn't just like volunteer that on NPR, right? Like he said that when pressed by your firm, and what I need to see is why did they press him to do it?
The cap means that when he was endorsing up to that cap, he was no longer a lost volume seller.
Right, when he was not up to that cap, lost volume. Above that cap, that's the argument, right? Now, who's right here? I don't know. I think either party could have really won it, but I do need you to see how the lawyerly push was to establish that cap and then point out that you were drawing down the cap so that you were reducing your capacity rather than saying, I could have done the additional one, which would have made absolute sense. And it's a huge difference in damages. It's a huge difference in damages between you need to pay me my costs, my anticipated benefit under the contract minus my costs. Well, my costs are showing up for 4 hours. So that's going to be a huge chunk as opposed to the other way around, which is like, no, you should have gotten another endorsement. By the way, let's say that Michael Jordan is asking $1 million, or $1 trillion. I don't know what we're supposed to say anymore with money these days. $1 billion if we update the meme, right? If he's just saying, like, let's say he asks, for $10 million per endorsement, which I still know is low. He goes and seeks an additional endorsement. What's he likely to ask? $10 million, which does what for our damages calculation in this case? It makes it zero, right? So we're talking about a huge freaking difference in the end of this case, which WorldCom has already lost. That their lawyers knew to develop this platform and how to use it. Chris, you had a question.
To back up L here, I don't know if the dilution argument works. He has his own shoe brand. He's an NBA owner. He's the second greatest basketball player of all time. It's unfair to draw the
Don't start a fight in my class. You don't say things like that.
It's unfair to draw this dilution line here with this pretty trivial endorsement, if you ask me, compared to his worldwide brands. I don't know if that's the line to draw.
Yeah, that's the place I would have gone too. I would have pointed out that he was still seeking extra endorsements globally, which a lot of US celebrities do. Like if you've ever seen Arnold Schwarzenegger on Japanese TV, it's hilarious. They have very, very different rules about dilution because they're operating in different markets, and so they're not being diluted. So all you needed to do was go global and then say, yeah, so there wasn't a cap. We're just considering this as part of our global portfolio, which we had additional capacity to meet. Maybe I would have shifted some of my other endorsements to global endorsements to replace ones in the US and maintain my total amount, which is an example of what in this class? Right? The answer is this. We need something like triple brackets or something like that to what you're doing, you're just shifting the community that you're talking about in order to shift your market that you're discussing. If the question is, do you have ability to meet additional demand in the market, expand or contract the market until you get the answer you want as a lawyerly practice tip. All right? Cool. Any further questions on that before we move on? Rock on. All right, so we are now done with mitigation. The one thing I want to point out on mitigation is this. Remember that our basic measure, either as an alternative transaction or if you didn't do an alternative transaction, a reasonable alternative transaction, heavily focuses on this idea that it's possible to do that alternative transaction. And so that's just the thing that I would like you to take out of this whole area. Keep an eye on it. The other thing is, those direct market measures, contract minus market measures, or contract minus resale would be your one, K minus RS, contract minus resale would be your one measure, or cover charge minus market would be your, or cover charge minus contract would be your other one. That these are ways of making it profoundly different, but profoundly clear, but also because of the minus component, they're already building mitigation directly into the direct measure of damages. Can you see that? By reducing damages by something. And what's the something? The alternative transaction that you either did or should have engaged in, by reducing the damages by something. And the amount that we reduce it by is by something you could or should have done. Even though the code doesn't directly say mitigation in it, I want you to see that they've actually built it directly into their formulas for direct damages. Mitigation is already there. And so when sometimes you'll hear idiots say, there is no duty of mitigation under the Uniform Commercial Code, you're like, well, then what's that minus market doing? What's that minus cover doing? It's saying we're going to subtract from your damages what you should have got if you'd arranged in mitigating activities. All right, cool. I think that's it. That's the only thing that I wanted to do as a coda to this. Let's turn then to Reliance and Hightower. Madeline, would you be willing to set it up for me, please?
So Hightower was a production company that started as a promotional venture
Yeah, this is very 1974, which was the year I was born, so I think this explains a lot about what you're currently going through. This is profoundly silly.
Yeah, so they had a profoundly silly idea where someone would live in a mobile flagpole perch to set a world record for flagpoles.
I mean, you do understand that this is what like flossing on TikTok looks like to me, right? Like profoundly silly. Okay, continue.
And so the venture was going to be publicized on radio and television. Council wanted to set a world record for flagpoles for them.
People with too many options for their time.
And so in order to do this, they needed money, obviously. So they approached
Obviously.
Paul Wartzman at a law firm for aid in opening a corporate, or for being incorporated. And so he helped them prepare and file the articles of incorporation. He also did help some to do this. So after he helped them become incorporated, they hired John Gordon to be the person to sit in the tower. They opened a corporate account and an office. They also obtained a company to construct the premises and two PR specialists as well. They anticipated that they would have a growing effect.
Mm-hmm.
They only raised $43,000 by selling stock, and another meeting had to be held because they were low on funds and no more stock could really be sold at this point. And the reason for that was because the law firm structured the corporation wrong, and they would need a security specialist to help them. And Hightower asked if they would help pay the $10,000 to $15,000 to hire this person, and they rejected that idea. So Hightower had to hire substitute counsel who told them that they weren't compliant with securities. The $43,000 was placed in escrow, and all these financial issues that kind of snowballed together caused them to abandon the entire project.
And the whole thing exploded. Okay, well done. Let me ask you one kind of further leading question. So, well, let me ask you the sort of advanced version of it. What's this case doing in the book?
Showing us how expenditures taken reliance on someone's representation.
Right. It's showing you reliance as a measure of damages. We are now on B, right? On my ABC that I started off with, expectation, reliance, and restitution. We are now on B, reliance. And the problem with reliance is we have heard those words before, right? They are the same words. This is the stuff that we've heard about in like promissory estoppel, section 90, et cetera, et cetera. What is the primary cause of action in Wartzman? What is the lawsuit? Never mind the damages. We'll get to the damages, the remedy in a minute, right? We're going back to earlier in the class. What are they suing for?
For failure to create a corporation.
Right, that's what they did. They failed to create the corporation correctly. By the way, this case should be required reading for every crypto investor out there, right? Like this is what I saw 5 years ago with that ICO initial coin offering, nonsense where people were just like, we're going to make whatever we want. and we're going to just issue coins to raise money. And the SEC came along and said, that's actually like that's a security. You can't, no, absolutely not, right? So there's a lot of people that got very loud knocks at their front door because of that. Okay, but what's the cause of action? What are you suing for here? The legal cause of action, strictly black letter. Suing for reliance damages. Dun, dun. Scott?
Is it breach?
Is it? They're suing for negligence and breach of contract. Now, negligence is a non-starter. Anybody want to give me a shot? What class is negligence? What class is negligence from? Torts. And why is negligence often a non-starter in these cases?
In contracts, the goal is almost never to punish people, and negligence and torts is very much concerned with punishing wrongdoing.
Right. It is. And here's the worst doctrine in contract law. It's so insane that I hesitate to mention it to you because it will do even more damage to your brain than illusoriness has already done. But there are a series of doctrines that police the boundary between tort law and contract law. Now, some states call them the economic loss rule, if you want to go into that. Others call them something like the primary source rule. But basically what they're often going to say is when the parties have decided to arrange the relationships between them, and the only damages involved are damages to finances, then we use their contract cause of action and we knock out their tort cause of action. Can you guys see that, roughly speaking? Torts need damage to person or property. I need a heart attack. I need somebody blowing something up. I need something burning. I need something crashed into. Those are torts. If the damage is purely economic, that's why this is called the economic loss rule, although it's so stupid and full of holes, it's barely a rule. But if you look at it, right, like for example, let's try this. We described the economic loss rule earlier. The two service stations near where I live, one of them is undercutting the other. That's why exit 217 is an excellent place to buy gas. They are causing economic harm to their competitor, but they never had any promise that they wouldn't, and there's no contract between them. And so we simply, without the Circle K doing things like setting the Liberty on fire, right, or blocking access to the Liberty, doing something to their personhood or property, we can't sue for tort, which means we're left with, what's our cause of action? Breach of contract is our cause of action. And now I want everybody to benefit from what we just did here, because I said, what's this doing in the book? And we said, well, we're looking at reliance damages, and we are. And the first thing I need you to see is our cause of action is breach of contract. That many of these cases are now demonstrating circumstances in which we routinely use reliance and restitution as a remedies measure, even though we have not sued for detrimental reliance, Section 90, and we have not sued for restatement third of restitution and unjust enrichment. Instead, we are looking at a series of circumstances that I will teach you to identify, and you can use on the bar exam and in your practice, to say, in a breach of contract action, when is the court not going to use the expectation measure of damages? When are they instead going to use the reliance measure of damages for breach of contract? Or when are they instead going to use restitution or unjust enrichment as a damages measure for breach of contract, not for a remedy for unjust enrichment? That is a cause of action you can bring. But instead, we're now talking about unjust enrichment as a remedy for breach of contract. And those are the cases that we're looking at here. Madeline, before I sort of open this up to co-counsel, or to opposing counsel, I mean, you can decide what side you want on this. Why? Why does the court do this? In a breach of contract action, why is the court looking at reliance damages rather than expectation measure of damages?
Because the anticipated profits would be too speculative.
Yep. Perfect answer. Okay, that is what I need you to take out of the case. We're going to talk about it. We're going to go back and forth here in a minute. I'll assign Mike as opposing counsel, and we're going to go back and forth about this because there's a lot to say. The black letter that I want you to take out of it, though, is when damages are too speculative, courts may consider reliance damages as a way of solving the speculative problem. That's when they use reliance damages for breach of contracts action. Sometimes they put them on the bar as new business cases. That's an easy flag for you to notice. A opens a new business, hasn't done business yet. They have a contract with B, B breaches, and as a result, A's business folds, which is what we're looking at here. And the court's like, yeah, I just don't know how much profit you would actually have expected, because flagpole setting, like the silliness that you remarked on, the silliness is kind of the point of it's the point of the case. The fact that it was silly means what?
It would have drawn viewers.
What's that?
I mean, if it was silly, it would have drawn viewers.
Silly would have drawn viewers.
Means no one's ever done it before. You don't know how much money you're going to get.
We may not know how much money you're going to get for it. It's apparently there was, even in 1974, and I can tell you this is a pretty crazy time to be born, right? But even in 1974, there was not a thick market in people sitting on flagpoles calling themselves Woody Hightower of all things. Which, man, are you kidding me? So yeah, like the weirdness of it, the silliness of it makes it thin, right? Like you could imagine industries where we're like, well, okay, we don't know what you would have made, but we can go look at a similar market and somebody, like people selling hamburgers, like, okay, let's just go look at McDonald's profits or whatever and say, we could look at somebody else. We can't even do that because there's not this developed, thick market in anticipated viewership for flagpole setting. So the silliness is directly related to why the case works out the way it is. All right, which way do you want to go? Do they get these reliance damages, or is this nonsense? Okay, so you're going to go for Hightower. Give me your best statement then on behalf of the law firm, which is good practice because like law firms are going to get drawn into this stuff. So one, there's no way that this is going to be profitable. And if you can't show any kind of profit, you can't recover for our breach. Madeline, what's your response? So one, why'd you sign the contract on it? Response? You're going to have to be a little louder. I'm having a hard time hearing.
I mean, it was just a contract for legal services. We weren't making a bet on the success of.
Okay. Now that one we're going to develop into the major critique of the case, right? We signed a legal services agreement, right? Hey, by the way, just like to develop this. So what's the theory of damages here, like beyond reliance? Because you get to stick to your guns on this, right? He says this wasn't the expectation measure of damages, and your response is like you haven't, right? He's saying you haven't proven damages, right? And you're like, well, that's so. We incurred substantial obligations. We know, Your Honor, notice they've basically conceded. We know you can't establish the value of the expectation measure of damages here, but Your Honor, that's not what we're asking for. We know that when things are speculative, you can ask for reliance damages, and that's what we're doing in this case. Okay, do you have a response to that one? Because now the argument's been cleaned up a little bit. They know that they can't prove future damages. You're still asking the firm to ensure your liabilities. Your response, Madeline?
Well, because there's a cap on reliance and expectation, that means the party's not a guarantor of success.
Oh, wow, okay. Like, give me the right answer right out of the market. Hell yeah, love that the most. Nailed it. Okay, that's a hard one to come back from, right? Like, because you could pick apart this. I do want to give this argument its moment, though. Like, let's just go after this. And let's tie it to other cases in the class. What are they asking you to do when you sign a legal services agreement? Like, think about this. You're signing a legal services agreement because you're gonna, y'all, every last one of you is gonna sign a legal services agreement. Do you love this case from your professional perspective? I mean, let me tell you this. What are you going to need to know in order to practice law after a case like Wartzman? The law, right? That'd be nice. Like, don't screw it up. Don't take cases you don't know what you're doing. Fair enough. Fair enough. You're probably going to want to know like what your malpractice coverage is for something like this, right? Whether or not you're going to get hit with it. Because what's your point here? Like saying, tell me a story about like, wow, this makes it hard to be a lawyer, or even impossible to be a lawyer if we took it seriously.
Well, now this is requiring the law firm to act as an insurer of the company's success effectively. So that means we would have to price it that way from the beginning, which would maybe make legal services prohibitively expensive.
We would have to price it that way from the beginning. Hey, where have we seen these kinds of insurance arguments before? Saying you're making me the unexpected guarantor of your entire damn deal, Fletcher? Bacardi and, okay, going to say Bacardi, so Fletcher and Bailey. Hang on a second, make sure I got you. And there's another one. Hayden? Hadley. Right, absolutely. Hadley is the same damn deal all over again. Is that a dangerous hand, Justin?
Yeah, I was going to say New Valley.
Tell me more.
In that case, it was kind of speculative as to whether or not the satellite would have been successful.
Right.
NASA's not the insurer.
Right, and so NASA's not the insurer. We see this argument come up a fair amount, and when we say we're not making you the insurance, what's our insurance of what? Because there's another deeper problem here. Like, what kind of damages would these be if we were looking at our standard expectation measure and not following Madeline's brilliant move to just move this over into Reliance? If these were expectation damages, what kind of damages would they be? Lost profits, which in some frameworks are consequential damages, right? And so now let me try this again, just as a practice tip, because each and every one of you is going to sign a legal services agreement. Are you going to, in that legal service agreement, agree to take liability for all consequential damages for mistakes within the legal services agreement? Hell no. You're absolutely going to, in your legal services agreement, and I know, because I sign these as expert witness work, going to say something like, damages in this case are limited to the fee paid. Right? Can you imagine insuring the consequential damages in the legal services market? Yeah, you might as well just play roulette with a revolver in your license, because like it is, just set it on fire. Like, at least you get some warmth for a few seconds, because there's no earth, right? Do you see that? Like, that's just insane, and we don't do it, and that's weird. All right, I just want to point that out. Like, Mike's got a real point here. Every one of you will have these agreements, every one of you will sign these agreements, and every one of you is going to be haunted by Wartsman, which means Mike's got a point. All right. Any questions about this one before we kind of leave it? Bailey, yep.
Yeah, please tell me if I'm going off on a weird path here, but so Reliance interest, like, so the whole reason that they do like Reliance is because like you can't ascertain what like the profits are going to be. Like, you can't look like there's
Yes.
no different.
Yep. That is, Madeline's statement is absolutely black letter. We use reliance as a measure of damages for breach of contract when the expectation damages are too speculative. That's the black letter law. If you take nothing else out of the class, take that. That's the point. Go for it.
So, but then it talks about how if full performance would have resulted in a net loss, and they can't it's whatever that is minus. Right?
Yeah, and it's that minus that creates the cap that Madeline's pointing
So
out.
I'm saying, like, if you can't even prove, or if you can't even ascertain what was going to happen in the future, how on earth are you as a defendant going to say, oh, this is going to result in a net loss? So then automatically.
Well, the defendant doesn't have to say, oh yeah, I see, as the defendant who's been held to violate. I get it, who's held to breach.
So how are you going to do it?
Yeah, it's not a great standard. I do not like the articulation of the standard as minus the losses that you would have incurred, because that doesn't capture the full range. I prefer the more common sense statement that reliance damages in most jurisdictions, because of this problem, are capped at expectation, because that much more clearly expresses what courts are doing with that reduction rule. You're right. There are proof costs that way every bit. I mean, there are some differences in it, right, to say I should have to carry the burden of proof. I should have to carry the burden of proof in convincing a court that if I hadn't breached, you would have lost money. That's a big statement, right? To say my breach saved you cash. That's a big statement, and so you should have to carry the burden of proof on it. But it doesn't capture all of the circumstances that Madeline's identified, where the right rule for a range of reasons is to cap reliance at expectation, because otherwise you get this wacky phenomenon where a lawyer essentially becomes the guarantor for the entire business. And the problem's particularly bad here because the flaw was within the corporate documents of the company, which means literally every expenditure that they took from that point forward could be chalked up as Reliance. It's not just ordinary business operations, like everything you did in this case was particularly nasty. But I don't care if it's particularly nasty. Like I'm with Mike, there's no way in hell I sign on to a legal services agreement that does that. Right? Okay, I've got Austin, then Nate.
Yeah, so I'm not sure how the law firm was held liable for any amount greater than $100,000 because they set up this corporation for the purpose of selling $100,000 in stock. So the only outlay or expenditures that could have been covered by the sale of that stock was limited at $100,000.
That's part of this Reliance measure, right? This is still the Reliance measure of damages. They're no longer looking at a pure D&G Bacardi kind of scenario where your resale is the Reliance. They're just saying, like, what were your receipts? And because it was a problem with the founding of the company, literally all the company's receipts for everything that they did in pursuant of this operation, the court started saying, yeah, that's legitimate Reliance damages. So it goes to the weirdness and the difference of out-of-pocket Reliance measures of damages rather than expectation, if that makes sense. Follow up? You look unsatisfied. Maybe I gave an unsatisfying answer. It's fair.
No, that's not it. The stock that they were planning to sell was less than 50% of the total amount of money they needed in the first place.
Yep.
And then within that $100,000, they were only able to sell $43,000 of stock. So I think part of it is just that Hightower wasn't able to raise money effectively. The only reason they had the meeting in the first place was because they needed to sell more stock.
They need to sell more stock. Okay, I got Fletcher, then Nathan, Lucas.
Well, so the 100,000 is the par value, and that's usually just for bookkeeping. Usually they sell stock above par value. So people's par value would be like 1 cent per share.
So one, this is par value, and that means that it's sort of an artificial number that we're not going to tie it directly to, but also it's not getting to the heart of the question around Reliance, right? What kind of damages are you looking for here, Madeline? Sorry, I caught you just exactly. I was a server in a former life, right? I know to ask you exactly when you've had a mouthful. Yeah, sure. Essentially, like, what kinds of damages are you saying are Reliance? Like, what kinds of damages, what kinds of things do you have receipts for that are not just a failure to raise the $100,000? Give me categories of receipts that you might have for things you did in reliance on them doing their job as lawyers that you might be charging for. Like, just give me examples. What kind of things might you have receipts for in this circumstance?
Like PR specialists.
Right, so they had to hire PR specialists. They hired a company to construct a flagpole. Right, do you see this? All this, it goes to the characterization as Reliance, as out-of-pocket receipts. They're no longer saying what would have happened if you had fulfilled the contract in terms of expectation, right? They're saying, what were your costs in getting ready to do the thing because we believed in you, and so we relied on you, and we get those out-of-pocket costs that we undertook in Reliance. The problem, as Mike points out, is the costs you undertake in Reliance in the circumstances is just like all of the company's ordinary operation costs. And that's what makes this such a wild D&G, Bacardi kind of, and Hadley versus Baxendale kind of case. Okay, I had Nate, then I had Lucas.
Just a quick clarification. What were the expectations of interest in this case? It was nothing because it was totally speculative?
We're not using the expectation measure of damages, right? That was sort of Madeline's first kind of, just like, nope, we're not even, I don't have to prove that because I'm over here.
And the second thing, Bailey and I were kind of trying to figure out why the judge really brought the hammer down and like found all these different receipts to put on this company. We were wondering if like this judge, it's like a local case, the judge was like sick of these people because the one guy, the litigation attorney, gives it to his buddy who doesn't know securities, and maybe these guys have been, I think, have really poor legal arguments, like he's just sick of them.
Yeah, I mean, I do think that there's a sense of professional, like, what the hell? Like, if you don't know what you're doing, don't. And that seemed legit to the court. Right. And also there's a little bit of like, look, the reason that the damages are speculative is because the reason we don't know what the actual damages are is because you breached, right? That's like, it's a rough road to hoe. Remember, there's this switch. You've been the villain for most of the case. Now that you're not the villain, it's still a little weird because you still like have all your villain hat and like your villain glasses and stuff. And the court's just like, yeah, but none of this would have happened if you hadn't been a jerk. Look good.
You already addressed the question I had.
Cool. Cool, cool. All right, any other things? Talia.
Would they also pay for the attorney and the attorney?
What's that?
Would the old attorney pay for the new attorney too in Reliance?
I mean, if that's what they have to do in Reliance, if they do that in Reliance on the Promise, although that begins to sound a lot less like, because at that point you knew of the problem, right? This isn't out-of-pocket costs that you undertook causally related to the breach of contract. This is like your attempts to fix it, but yeah, like they seemed to tack all that stuff on. They put the costs into escrow and that kind of thing. But again, reframe them for a minute, and you can see these are consequential damages that any legal services agreement would have, and I bet the legal services agreement in this case did bar. And certainly none of you are going to leave consequential damages open in your legal services agreements. Are you kidding? Yeah.
So if we bypass expectation, it's too speculative.
Yep.
If we go past Reliance.
Yep.
And you only get what you paid this law firm, who ultimately turned out not to be very good at what you needed them to do.
Yep.
Are we more in the realm of restitution at that point, since it's just about keeping them from maintaining the spoils?
Yeah, at some point we are going to switch over to another set of circumstances that are not the two speculative circumstances, but are the you breached and got something you shouldn't get circumstances, which we start using restitution as the damages remedy for breach of contract. That's exactly that scenario. Absolutely. Anything else on this stuff before we move on? Yeah, go ahead, pleasure.
So you said in our contracts we should like say no consequential damages, but this is a reliance damage, right? So that wouldn't have protected them here?
Well, that's the thing. It does give you a shield because the reliance damages, among other things like the damages you suffer, it's clearly the expenditures you've taken as a consequence of their problems, and so it fits Hadley versus Baxendale. But reliance damages is something different, and so this is one of these framing questions. Like if you can get the court to see this in terms of consequential damages, they are waived. If you get the court to see them in terms of reliance damages, they're not. That's why the lever pull works. It's not that it is one thing or another. Does that make sense? It's whether you can get the court to adopt that framing. Okay. Let's move on to exactly where sort of John was taking us, and this is going to be to Mobil Oil, and then we'll move on. Well, let's do, hang on a second. Yeah, let's move in. Let's do Mobil Oil and restitution because we just had this so nicely queued up. So we're talking about Restatement 370, Restatement 371, and the Restatement third of restitution and unjust enrichment, which governs unjust enrichment directly. And so this is going to do Mobil Oil. And Kat, if you wouldn't mind setting that up for me, please.
Basically, Mobil Oil and their company sort of have this government a 10-year contract, which would allow them to sort of given them the rights to explore to develop oil on the coast of California. The contract has some kind of clauses and regulations, including that Mobil had to get approval from the DOI, the Department of Interior, and the state of North Carolina under some sort of like legislative mumbo jumbo. Anyway, there was a lot of influx happening regulatorily.
Right.
So after Mobil submitted a plan for exploration, Congress passed a new law that delayed approval of any exploration plans at all.
Right.
Their contract had like a clause that said the government had to like sort of approve or not approve it within 30 days.
Mm-hmm.
And this plan, this new law that delayed approval kind of threw that whole thing threw a wrench into everything.
Mm-hmm.
And so the Department of Interior told Mobil that their plan was good, but they couldn't approve it because of this new law. Mobil then sued the government to get their money back.
Yep.
The federal court found that the U.S. had broken its contractual promise to follow that provision requiring the Interior to approve the plan within 30 days.
Mm-hmm.
And thereby they had like repudiated the contract because the government literally told them, hey, we're like not going to do the things that you
Yeah, we're just not going to do this. Yeah.
And they just like said it like that, and the court was like, you ought what? So the court found that the lower court found that the government's repudiation entitled Mobil to restitution of the upfront cash bonus payments, which is $150 million,
Right.
And appeal court reversed, and, that they appeal again. So, essentially, the government is sort of arguing that it didn't breach the contract, even though it literally said it was going to breach the contract.
Yeah, right, which is a rough road to hoe.
The court had fun with.
Which is sort of a follow-on. So they said they didn't breach it, but then what's their more serious argument?
Was the government's more serious?
Yeah.
Well, they're like, we can't follow through with this contract because of this whole legislative thing, like where our hands are kind of tied here.
Right, by whom?
By us.
Yeah, okay, so that resolves that problem pretty freaking fast. Like, well done. Yeah, like I've tied my hands. I can't perform my contracts, and the court's not having it, right? Like, just absolutely not. And then they have a couple of other.
Yeah, they also argued that if they had breached, that breach wouldn't be substantial.
And what's that argument? Because we're going to see this insubstantial, a little breach. Like, imagine you order a car and it gets there a day late. Did they really breach? Like, maybe you get damages for like the day late. But did they really breach, right? So you could get that kind of argument.
Yeah, the government was like, well, they can't do the thing, they can't do the contract at all if you don't prove the thing. So it's
Right,
not
so-
insubstantial, it's actually very, very, very substantial. These companies, these little companies are,
Right,
just sort of sitting there holding their hands,
Right.
waiting for this.
okay.
And then they also argued, which is kind of crazy, that Mobile waived its rights, its restitution rights by like continuing to ask the government to do what they said they were going to do.
Right.
Which, the court was like, that's nonsense. So, where am I at?
I mean, you've mostly covered almost everything, but if there's any sort of a final coda you want to put on it.
Well, yeah, I would just like the court was like, no, you definitely have to pay them because timely and fair consideration of those claims is a necessary reciprocal obligation.
Yeah.
And that contrary interpretation would have rendered the bargain illusory. So in essence, it was totally inconsistent.
Legit, right.
They can't claim that the U.S. can't claim that the companies waive the rights to restitution by urgent performance of the contract because that's insane. And the dissent brought up something I think kind of interesting, where I think it was Breyer kind of said that, well, like, I don't know if restitution is appropriate here because all of this is just like a 13-month delay. And so the contracts could potentially happen in the future if I'm remembering this correctly. So,
Right, we're not doing it. Like, at what point does that ripen into, yeah, it's not going to happen, right? Which is a different thing. Yeah, perfect. Okay, let's just start here with a few real basics. First of all, what's our cause of action here? Okay. Yeah, breach of contract, and what's our remedy? Like, I'm just going to be super pedantic about this. Restitution, right? And I just want you to note it, and that's weird. That it's not our measure of damage. I'm going to make it less weird here in a second. In fact, I'm going to make it, as John was pointing out, like absolutely bog standard. But I need us to get to, like Madeline's point where we said, okay, we use reliance instead of expectation where the damages are too speculative. I need us to get to like a one-sentence statement of when we use restitution for breach of contract all the time. Now, I will get, if you want to take a swing at it, I do have some guiding questions, but like if you want to take a swing at it, what's the one-sentence statement of when we use restitution as a remedy for breach of contract? Because you said it like it was just this little brief moment, and I marked it down. I was like, this is brilliant. What's the restitution component of this?
the payments that they have made to the government.
Yeah, yeah.
Like the prepaid.
The prepaid stuff. The prepaid stuff. And what's the remedy doing here with the prepaid stuff? I'm seeing some fingers. Yeah, Madeline? Give it back, which is actually literally the title of one of my recent articles. Give it back, right? Okay, so this is the restitution component of this. What I need you to see is, on the one hand, again, not the expectation measure and pretty weird. On the other hand, let's just test this. You can now all stop being lawyers for 5 minutes. You're now humans. Take a moment. You're humans. Have you ever gotten stuff in the mail from Amazon that was broken? Yeah, and like you're like, I don't trust you anymore. Like, I don't want it anymore because like this sucked. And so what happens at that point?
Well, they refund you.
Yeah, they refund you, and what do you do?
Something else with that money.
Yeah, something else with that money, that's true, but what do you do with the thing that you got that sucked?
Oh, I throw it away. They don't want it
they don't want it back, right? And if they asked for it back, you'd have to send it back and they'd have to foot the bill for it. But generally speaking, by the way, they don't want it back, which is how I ended up with like 3 pairs of running shoes because they kept sending me the wrong ones. And I was like, do you want these other ones back? And they're like, no, you can keep them. I was like, this is not great for my incentives, but okay. Yeah, it's a restock cost, so they just don't do it. Look, what I want to do is tie this to your day-to-day experience. When an ordinary transaction falls apart, a lot of the time, what do the parties want? Like, never mind law. Just look, what do you want when you got a shitty product and you don't want it? Especially in the modern internet, highly commercial ecosystem. Look, you just want a refund, you want to send it back, you want to erase the transaction, and as Kat says, take your money and do something else with it, right? That's this huge area where we use restitution as our default remedy, as the big remedy, as the constant remedy. We use it all the time when what happens is one party has prepaid the other, the deal falls through, they want their money back and they want to go about their business and they just want to use that somewhere else. They want to undo the transaction. They want to undo the transaction and get their money back rather than push through. What I need you to see is how that's both a natural thing to want. Everybody gets that? Totally natural thing to want, everyday thing. In fact, restitution is more, you have in your actual lives benefited from a restitution remedy far more than any of these other remedies. In your experience, restitution is just the standard deal, right? And then the second thing I need you to see, first I need you to see, oh yeah, that's true. Second, I need you to see though that it's not expectation, is it? No, like what would expectation look like, by the way, in a case like this?
Specific performance, I feel like is.
I mean, specific performance might be, except you get specific performance in the case of land, Picasso's, or sole source of supply under the Uniform Commercial Code. That's where we're going to get to by the end of the class. You get specific performance for land, Picasso's, sole source of supply under the Uniform Commercial Code, and you don't get it otherwise, right? So what's another remedy that you might seek, and how would that work out? What would expectation measure look like? I got Talia, then Riley.
Oh, I was going to say alternative.
So alternative performance, right, Riley?
Just lost profits on all the oil.
Just lost profits, or by the way, on all the oil, construct me a remedy that's kind of make, if you can't do an alternative transaction, right, because only the government can approve these oil contracts, you can't really do an alternative transaction. But give me your instinct about like how you'd try if you had to, which is not this case. If you had to construct an expectation measure, how would you do it, Gene?
So for alternative markets, so they maybe can't inspect around the shores of North Carolina and the Outer Banks, but maybe we can send you down to Pensacola, have you look in the Gulf.
Right, so we might look at like reasonable alternatives, give you some kind of alternative transaction. That would be great, and if we can't, then what do? If we can't arrange an alternative transaction, John,
You might say, here's how much money this company made off the coast of Florida, South Carolina.
we just go to a hypothetical market. We weren't able to find you another contract, but we can go to another contract that's out there, and we can see how much they made or how much they didn't, right? And that would be our measure of damages. What I need you to see is restitution is a routine measure of damages where you are returning prepaid fees. Routine. And I need you to see that it is not at all the expectation measure of damages. It's not at all the expectation measure of damages. All right. Any questions on that? We are gonna do a few, like we do need to do a few follow-ups with the case, but I just want to make sure that we get those points nailed down. Nate, yep.
How does the court justify giving back the whole amount of the lease cost when that's part of the transaction is like that the government has all these costs associated with approving the project?
Right?
So there was partial performance combined with the Department of Interior. So I'm like, I can see them getting a huge chunk of their money back, but it is cost to these.
Well, first of all, let's just address a few things. Partial performance matters in what part of this class?
I was getting the repudiation thing where like you don't fully repudiate and then you allow.
Right. And we'll have to talk about this repudiation thing because it's a really common scenario when you're doing business with somebody else. They don't just pick up the phone and say, we're breaching the contract. They start getting squirrely. They start not taking your calls. and delaying and saying they're going to get it done and trust us, this is going to work out, right? And we have to have a whole process of actually kind of forcing the moment of repudiation. It's a little bit what the dissent was going on about, saying, well, they haven't said no yet. Like, maybe we could just give them infinity to decide. Wouldn't that be cool, right? So there's that, there is that repudiation component to it. I do think that underneath it all, of course, and anyway, yes, and we'll talk about it later, how to flush that repudiation component out into the future. But for now, the point is, yeah, they breached. Like the court just decided you tied your own hands and then you breached your own contract, and this is exactly the same as NVC. The court's gonna be pretty sarcastic when the government's like, I tied my own hands. I can't perform my own contracts. Like they just don't care. Okay. We do need, I want to make sure I get any other questions about this, sort of where we're starting with it, because we do need to kind of bear down on it just a little bit more. Okay, well then, I guess what do you think then convinces you that, what's the best, let's come back to this, what's the best argument that the government's got for this? Because they clearly breached, right? Like,
Yeah, I mean, I was just thinking about that. I think that, and I don't know if this argument would work, but, and I don't even know if this is related, but these two government entities like don't even talk to each other.
yeah,
You know what I mean? So like, this is like a sort of like friend situation. Where it's like,
Yeah,
not really friends,
right.
like a friend.
yeah, like it's a self-inflicted wound. Like your left hand's not talking to your right hand,
Yeah.
right? Like this sounds like a you problem, I think is overwhelmingly what the court says.
And the government's like, oh, that department does their own thing, and like, we had nothing to do with this. And
Right.
have you ever tried to do like a marketplace health insurance thing and deal with your state? Like, they just, nobody talks to each other.
And I think that's the driving impetus for why, it's a little bit like TVA the last time the court trotted out restitution to drop the hammer, remember? I love the reference to Fred, right? Saying, oh, well, we took advantage of this contract, right? We took advantage of this contract, you did these microfiches for us, we signed a contract, we agreed to pay a certain amount on the contract, and now we're trying to get, and he performed, and now you're trying to get out of it because one part of your company said that the other part of that a person working for your company wasn't able to sign the contract. Are you kidding me? And I want you to notice that's when the court trotted out restitutions like, I really don't care whether there was a contract. And so that ties it, I think, well to the rest of the course. This is basically TVA again. It's a Fred case again. And then I guess, can anybody give me like what, if you really had to win this case for the other side, what's your best shot? Like the government's dead to rights. This idea that it's a self-inflicted wound, that they just weren't talking is not very great. Yeah.
Could you make the argument that there was no guarantee that they were going to get the contract anyways because North Carolina had the reserve right to...
Yeah, tell me about that. And how would you link that to legal arguments?
You'd say that North Carolina sort of as a, like, in the sense that like the board of directors or like your attorney are an agent in a way?
Yeah.
Like...
Well, would you want to say that they're No, you don't want to say that they're agents. You'd say they're independent and therefore...
Independent, like, oversight, basically.
Yeah.
And saying like, oh, this is a good deal, like, we'll do this.
Right. That is, you wouldn't have been able to do it anyway. You wouldn't have been able to do it anyway, right? Which is, and then did anybody, Kat, I'll come back to you, but also open it up to anybody if you like, you get priority. What does the court kind of, it does grapple with that a little bit, and it says...
The court says that there was like there was no guarantee that it would have been approved by the North Carolina element of the...
Anyway, and so...
So that thereby, like therefore, the government shouldn't be on the hook for this.
Yeah,
They weren't, otherwise they're not guaranteed, they weren't trying to guarantee that this was...
right, that wasn't what the contract was for. What was the contract for? It wasn't for approval, it was for... It was an options contract. It was basically saying, get me through this point in the approval, and then I have maybe the possibility to go do these other negotiations, right? But they lost the possibility. They lost the option. They paid for it, and they lost it, and that's why the court maybe begins to crack down on it. All right. Any other questions about this one before we move on? Cool. All right, then we've got Palmer Construction, which, is going to come as an enormous surprise to everybody because Madeline's already done a lot of the work on it, but we're going to pile in on it. And Mike, if you wouldn't mind setting up Palmer for us, please.
CSE was the general contractor for building a power plant for the Air Force. They contract, Palmer was a subcontractor of theirs. They had a contract with them with the value of $204,000 for their services. Palmer reached, and then CSE sued them. Palmer's, like at the time, Palmer supplied, had partially performed the contract.
Mm-hmm. Yeah, that's really key. So what then matters, when they partially performed, then they,
So CSE had already paid Palmer $114,000.
yes, they'd already overpaid some of it, so we know restitution's coming, right, in one way or another. But then Palmer does what? Because this is the key here. Like, they partially perform. They start building this thing, and then they stop, and that's absolutely, right? So we're back in restitution as breach of contract territory, right? We're back in restitution as breach of contract territory. And what does that mean then for, and that's basically it. Like, what's the measure of damages they're looking for here? What's the amount in damages they're looking for?
Restitution is the original. I guess it's the difference between what they.
Yeah, it's really hard, isn't it? Who's suing who for what?
CSE is suing Palmer.
Yeah, CSE is suing Palmer for breach, and Palmer's doing what? This is really important to see it. Lucas?
Well, Palmer spent or gave the value of $200,000, and then they only paid $114,000.
Okay, right? So that's that 80,000 plus differential that they're suing for, right? The idea is, I need you to understand who's, for this part of the case, who's getting a remedy from whom? Because this is what defines this area of law. We have two places where restitution routinely gets used. That's what we're walking through. Place one is returning prepaid stuff. Place two is this, and we're trying to figure out what's going on here. Who hasn't been paid for what? Lucas, can you say it again?
Yeah.
Who hasn't been paid for what?
Palmer hasn't been paid for the $204,000 of value that they gave to CSE.
Okay.
They've only been paid $114,000.
Yeah, all right, so they're suing them for the $200,000 in value that they've been sued for under CSE. And that fits to our circumstance here, because what's our cause of action? What's our cause of action? Breach of contract underneath, but then what's this person suing as a cause of action? What's Palmer using as its cause of action? Because, yeah, they're suing directly now in restitution. This is not a breach of contract case for Palmer. Why? I'm being pedantic. Why is it not a breach of contract case for Palmer? Aiden? Because they're the ones that breached. All right. This is the second place where we see restitution routinely in contracts causes of action. It is a claim raised by, get this, the breaching party, which can't get paid under the contract, but which can get paid under unjust enrichment. Okay? And therefore, the second place where we routinely see restitution in breach of contract cases is when I sue you for breach of contract, and you sue me for restitution for the amount that you did before you breached the contract. Okay? Now, the reason I've come back to you, though, Mike, is because this is the same problem all over again. I know you've already done good service today, and I've been pushing you on it, but the reason I came back to you is because this is the same problem that we saw already, right? What's the issue? Can we identify the problem here? Let's say they've been paid $114,000, and then they've been paid $114,000, and then they get paid the additional, $86,000 that they're due because of the difference in the value of what they produced. What's the problem with this picture?
So they offered to perform it the 204,000.
They offered to perform what for 204,000? You're on the right track. The whole damn project for 204,000. Now, let's try our alternative remedies here. What would it have looked like if CSE had gone and gotten somebody else to complete the project, which in fact, like, they freaking did.
So CSE paid 241.
Say 241 to do what? Say it for the backbenches. To finish the contract, right? So can you imagine now, they've paid 241 and damages in this case are, the claim for restitution is? So 80, 86 some, right? Which means you've paid 241, you're already out like 114 because you paid it, right? You then paid 241 to finish it. So now the total outlay that you've put out are your 114 plus your 241 you paid somebody to finish it, because you paid 114 for them to get halfway there, or part of the way there. You paid 241 to get the whole thing finished, which is more than the price that they agreed to do the whole thing for in the first place. And to add now stunning amounts of insult to injury, say it for the back seats, what's the breaching party claiming for now? How much are they asking for now? $86,000 roughly on top of that. Whew. Where did the court go wrong? Oh, by the way, Mike, do you want to hit us with like the black letter law here? Like, what's the black letter law of restitution in these cases?
CSE can't be required to pay more than the contract price.
Well done. Well done. Well done. It's the same insurance capping function that we identified previously. That we're going to cap, because otherwise, as you pointed out in Wartzman, if you're going to cap it at this, amount, because if you don't, then they become the guarantor for the whole stretch. And so we're not. We're going to say, as a matter of law, then, Judge, what are you going to set recovery at in the, and by the way, anybody want to open this up to everybody? What caused the problem here? Why is restitution so wackily different? Like, everybody gets that if you partially perform and breach, you should be paid the fair market value for what you partially performed. Like, we get that. What caused the wackiness here? Yeah.
They had massively underbid.
They had massively underbid, and we know that because
Halfway through, they had almost used up all their money, and they said, I'm not going to do any more work. Goodbye.
so I'm not going to do any more work. And the second way we know, so they ditched the contract. That's one reason we know.
Complete it, they had to spend another $100,000 to get it done.
Right, and then they had to spend another $100,000 to get it done, which is going to stack even more on top of that. We're already over the contract price now, which means who owes who what in this case?
Breaching party has to pay.
The breaching party has to pay, and roughly speaking, by the way, how much should they have to pay? Jake, yeah? No, I was going to say Jake, but then I heard Gene say it too, so I'm going to come right back to you. You're right. How much? Yeah, the amount extra, right? Like if you've already paid 114 to get it partially done, and then you had to do whatever amount extra to get it done. What's that called? Cover, or your alternative performance. Cover we use for the UCC, but this is an alternative performance. And what are our damages remedy? The difference between the alternative performance that you paid to get it done and your contract price. We're already over this. Can you see they're not going to get a cent in restitution? We're already over. Palmer owes CSE, and for this case to come out any other way is just nonsense on stilts. Final word?
This requires the one party to insure the other.
Yeah.
Making a bad deal with that.
Yep, absolutely right. Yeah, that's exactly it. That's one of the reasons why I wanted to come back on this. It's the same case over and over and over again. You're asking here the non-breaching party to ensure, based on the court, of course, coming up with this huge valuation for what the value of the property was worth, probably caused by the underbidding, right? Okay.
How do you think it even happened that the original district court was somehow going to charge CSE excess of what they decided to contract with? Like, it seems like that's like kind of an obvious error.
Yeah.
Is that
Yes.
why it's in the book? Like,
Yes.
it's so rare?
Yes, that's exactly why it's in the book. We're not doing that. And I just need you to, what I need you to take out of this case is I need you to take one, the area where you're going to see it. The restatement here makes this clear. You will see this when the non-breaching party is suing the breaching party and the breaching party is suing back for the amount that it is partially performed. We routinely see this restitution measure under those circumstances. And the second thing I need you to see is exactly what we were going over here. We're going to cap that restitution measure by the breaching party at the expectation measure of damages, because to do otherwise is going to require CSE in this case to cough up a whole pile of money to give to Palmer on this that just is not warranted. They've already, by the time of this litigation, they've already paid more than the contract price in an alternative transaction. We're not getting restitution in this case. Questions on those two things? Hayden.
Is there a fact pattern in which the non-breacher would?
Absolutely, all the time, right? I mean, like, let's try the standard one under the UCC. The standard one under the UCC is I get, I don't even know what's like rare enough these days. And I don't want to use Labubu because like, I don't even know what one is. And I'm just going to like out myself. Like apparently it's this weird thing people wear around their necks. I don't know what it is. What's going on? Labubu, so let's just imagine you get some good. And it might or may not be a Labubu. And it's got a problem with it. And let's also imagine that you just don't want to go through this again. You just want to solve the problem. Like you just want to patch the issue. Right? Can you see that you might prefer to just keep it, but then you need to pay them the amount that it's worth minus the cost of fixing it? Like you're going to pay them what it's worth. You still have to pay it for them. You still have to pay them for it because they're keeping it. But you're going to pay them the market price, the contract price you agreed to, minus whatever it costs to stitch up like whatever we need stitching up on Labubus. And that's a pretty common, like they did give you something, it just sucked. It was less than what you expected under the contract. And you still have to pay for that. Like you don't get to keep that. And they breached, so they can't sue you for breach of contract, but they can breach you, but they can sue you for restitution if you don't pay them the fair market value of whatever you got out there. So that'd be a real common scenario. Other questions on this stuff before we move on? Liam, yeah?
So in the Hightower case, they had gotten enough money to get the specialist to fix the specialties contract. Would they have been able to go for restitution damages?
Probably not, because they weren't the ones who breached the contract. They wouldn't want to. But they certainly would go for reliance on the rest of it, or of course their gold standard would be expectation if they could convince the court that flag sitting was a wildly lucrative business opportunity, like that kind of thing. All right, we'll pick up it with all metals next time. If you've got any further questions, please feel free to see me after class. Thanks so much, folks.